Hi everybody, this is Gary Fong, and a photographer just sent me this contract to get my opinion on, just as a former studio owner and a person who has been embroiled in constant lawsuits for the last 19 years, including a copyright infringement, trademark infringement lawsuit that went to a federal jury trial, and so many more lawsuits. I definitely know a lot about getting embroiled into disputes with parties, and a lot of the reason is because the contracts are maybe a little bit murky, or there's always a battle over the paperwork. And the paperwork basically means that you're going to a judge and saying, look, we have a misunderstanding. I say this and the other person says that, and that's where the problems come from. So in a contract, when I look at one, there are three basic handles that I look at as a filter. Even when my own attorney draws up a contract, I look for these basic things to make sure that they're done correctly. Number one is, of course, the parties. The parties is very, very important because of how it's named. Is it the corporation? Is it this person? When you say certain things like all other rights and assigns and blah, 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 holy smokes, that sentence right there could also open up a little tiny can of worms. So that's one called the parties. The second is called the definitions, and the definitions, I think, are probably the most important part of a contract, equally as important as any other part, and that's because the definitions say what it is specifically we're talking about. And I'll show you in very, very clear this example here. Under assignment confirmation, it says the contractor specifically ordered and commissioned by the studio to create the material specified here in the work, and there's 4 lines. That is the definition. If you say in the work, all photographs taken by associate photographer, then you have basically an unenforceable contract. And the reason that is because that photographer could say, what do you mean? Even like photos that were taken on my iPhone, I have to give those to the studio. But all photographs taken at my holiday holiday or whatever, those things are very, very important to define discreetly, concretely, and with a very, very tight, what they call chain of evidence, what those items are, the subject items that we're basically talking about in the definitions. So that's really huge. So you have the parties, the definitions, and of course the consideration, which means the money that changes hands. And what else is there in agreement? Agreement could also have what we call jurisdiction, which means that this is the area that this covers, and then also the time frame of that contract. How long will this contract last? And those things are always the things that I look for when my attorney drafts up a contract. Now, I'm going to just briefly go over this contract very, very quickly, and then you can come back later when I'm going to do an expanded course on understanding legal agreements in my premium channel. But let me just go through this with that filter, thinking about all of the things that we see here. We'll go down here, the parties. Now, can I just say this? It says this agreement is entered into and effective as of by and between studio and contractor, blah, blah, blah. Now it says here under paragraph 2, this is kind of a minor thing, but it isn't. It's annoying. It says the parties, but it doesn't say, it doesn't really define parties. What it should happen is right up here where it says the agreement is entered into effective blah, blah, blah. These constitute the parties. That's one thing that could be said in here. But it says expressly agree that the work shall be considered a work made for hire for the studio as that term is determined in section 101 blah, blah, blah. That goes to these 4 blank lines here, that the work shall be considered a work made for hire. So if you say something like, well, wait a minute, Your Honor, I took that picture of my parking spot so I wouldn't lose the space. Are you saying that under this contract it's a work made for hire? Well, apparently so. And then what happens is then they can say that the contract is poorly worded, that's outside of the terms of the agreement and everything like that. Now let me tell you what should happen in those 4 lines. Those 4 lines should say the cards that marked in herein as exhibit A, and AB, 2 compact flash cards, which basically have been determined to be shot only by the second shooter. Now this is basically what happens. This is what I did. I would have a sheet, and that would be the digital file control sheet. In that digital file control sheet, the photographer would be handed a number of compact flash cards. That photographer would sign off, I have received cards AA, AB, and AC, John Doe. Okay, so, and that is at the beginning of the event. That photographer then shoots those 3 cards and then hands over those 3 cards and then signs off and says, verifies and testifies that that photographer did not shoot any images on any other media except for cards AA, AB, and AC. Do you see why that's important? That's important because that photographer is now saying that they have no rights to any images outside of those three cards. If, for example, what happens is you get in a fight with that photographer, the photographer says, look, under copyright law, the minute I take a picture, I own the rights to it, and I don't want that mean bully studio to ever use any of my images again. And they go to a court and they get an injunction, and the court says, what images are you talking about? He says, well, you know what? I shot pretty much at every event for the last 2 years. So then the court will say, well, what are you enjoining? Well, unless the studio can prove otherwise whose images those are, they cannot sell any images for the last 2 years. This is a nightmare situation, and I actually saw it happen in a studio in Los Angeles, and it was over a celebrity wedding. One of the associate photographers said, look, I'm leaving. I don't like the studio. You can't use any of my images, and I want my images for display purposes, for advertising. Studio had a contract. Contract said, look, any image that you take is now property of the studio. It said something like that, really in bold, dumb terms that are unenforceable. Really, Your Honor? So I took a picture of my infant being born, and that is now, I can't use those? Because of what? Because of this other corollary agreement that comes outside of the copyright law. The copyright law trumps everything. So anyway, what I'm saying is this, is under the definitions, if you have the files clearly defined with an unbroken chain of evidence that says that these files were taken by the associate photographer, then you have got yourself this defined really well. But what you also need is the transfer of the rights of those images to you and the United States. That is done through what's called a TA form, a transfer assignment form filed with the Copyright Office. So what would happen is this. Your second shooter goes out, shoots an event, gives you cards AA, AB. You make a DVD of that, and you give one copy to that photographer, one copy you keep for yourself, and then you send that DVD over to the Copyright Office and file that with a transfer assignment form. Now you have got basically just a dead nuts evidence and transfer of copyright that makes any agreement pretty rock solid, unless it's screwed up. And so as I look through this one, paragraph 3 says, to the extent that the work is determined by a court of competent jurisdiction, which would mean copyrights go under federal court, but then federal court, the wording says it's determined by a court of competent jurisdiction. So determined by who? Do you see what I'm saying? It would have to say that this work, well, this paragraph 3 has to go, period. Not to be, if it's determined that by a court that it was not a work made for hire, the contractor agrees to execute any or all documents deemed necessary to transfer, to take the TA form. So let's play out paragraph 3 with me. Let's play with this. So this guy says, look, I don't want you to use any of the images for the last 2 years. And you say, okay, we're going to take this to court. You take it to court of competent jurisdiction, and they, after a lengthy trial, make a determination or a ruling. And under that ruling, the ruling says that it's not, if it was, that these are not a work for hire, that those actually belong to the studio. So now the court is going to order the associate photographer to do the TA form. TA form for images that you don't even know who took if you don't have it very tight as to who took what images. So that, then it goes down here, promptly make all changes, blah, 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 artist right, moral rights. Oh, God. Can I just say this, as I'm looking through this, and then upon execution, second payment. Okay, so this would have to be done with every single event, and it's called an assignment confirmation. confirmation just is basically an understanding, but it's not a transfer. The transfer has to be done with a TA form. And now let me tell you about this thing that I just got emailed. It was sent to me by a photographer who said, I'd like to use it, and another photographer had it, and it was okayed by that photographer's attorney. You know what? That's complete bullshit. No attorney would say that this contract is enforceable. I don't see the venue or that at all times contractor acknowledges that at all times contractor is an independent contractor and not an agent, employee, or representative studio. All times into the year 3017. This is a garbage contract, and I need to tell you this. Do not take any agreement from the internet and just say, ooh, this is going to happen because I trust you. You are not. This is actually worse than not signing a contract, in my opinion. I wouldn't. Here's what you need to do. You need to have an attorney fill out the contract, but you yourself need to have knowledge of what goes into a contract. You need to know what the definitions are, and that's important because an attorney who doesn't work with photographers might not know what the definitions are. What exactly is work for hire? What exactly is an image with copyright? Might not know how to specifically define the parties. So you yourself as an individual need to write out exactly what you want the contract to have. The time limit, the duration, the consideration of money, the parties, what the subject property is that is being discussed in this. And once you know that, and I'm going to have a really, really good long video course on exactly how to understand the basics of ordering a contract, then of course you need to get an attorney to then go through and make sure that the language isn't stupid like so many that I've seen. Anyway, I hope this is some help for you. I hope that this gives you a level of concern, because it should. I have faced many lawsuits, and there are many reasons that these things happen, and these are all from lessons that have been painfully learned. Okay, so make sure to subscribe to the channel. Keep tuning in. Subscribers always get first crack at the content, and stay tuned for my premium channel, which will have complete long duration courses on all of these very, very, very important topics. Okay, thanks for watching. Bye.